His dedication and devotion towards law, coupled with the aim of imparting quality education and encouraging young law students, did not let him stop after his retirement, and he accepted the position of chancellorship at the Aligarh Muslim University. He was conferred with several international recognitions and honorary degrees. He was a member of the American Inns of Court and was conferred a degree of Doctor of Laws honoris causa by the University of Leicester, England. He was nominated to various international committees and led several delegations and missions to East Timor. He was conferred with several international recognitions and honorary degrees. He was a member of the American Inns of Court and was conferred a degree of Doctor of Laws honoris causa by the University of Leicester, England. He was nominated to various international committees and led several delegations and missions to East Timor, Liberia, Bangladesh, and Zimbabwe. When I had been offered judgeship, I had the opportunity to seek the advice of Justice Ahmadi. He was one of the arbitrators of a 3-member arbitral tribunal where I was representing the Reserve Bank of India in a dispute with a Canadian banknote company. On the last date of the arbitration in Ottawa, Canada, I sought an appointment with Justice Ahmadi for a personal matter. With a heart ready to help, he readily gave me sage words of wisdom. As I was still contemplating on whether to continue with my decision to accept judgeship, I asked him whether, after having spent his entire career in service, he still thought it was all worth it. Without a moment of hesitation, Justice Ahmadi said, "Absolutely worth it. I have not regretted a moment." And he said to me, "Do not look back, for I have never looked back." The life so well lived by Justice Ahmadi shows that the value of a true leader lies in the next generation, which he inspires and mentors through his words and actions. Justice Ahmadi has influenced multiple generations of lawyers and judges, including me, with his exceptional life. Throughout his illustrious career, Justice Ahmadi was known for his tireless work ethic, sharp intellect, and unwavering fidelity to the highest constitutional ideals. He was a beacon of hope for those seeking redressal through the legal system and was respected by all for his integrity and impartiality. Justice Ahmadi shared an unbreakable bond with his wife, who predeceased him by 6 months. There is an abiding photograph of both of them sharing a tender coconut, a dab as we say in Bangla, or a shahada as we say in Marathi, and smiling contently and peacefully. 2 straws sipping a single tender coconut. About his wife, he once said, "She is an unsung hero who always believes in work and not credit. To me, she is a great life partner, friend, and guide, who also had a great sense of understanding and respect. She has indeed made my life easy and happy. I am highly grateful to Allah for giving me such a nice life partner." As I said earlier, since she provided directions to him when he drove his Fiat car, he would joke that she is his guiding light. What my own elder sister said of my parents applies or describes the relationship of Justice Ahmadi and the spouse. They were truly a package deal. On a flight from Delhi to Mumbai, when I was a young lawyer, I happened to occupy the seat next to Justice Ahmadi while his wife was seated across the aisle. When I offered my seat for her to occupy, Justice Ahmadi waved me to sit by him and tell him something about the legal profession as a young lawyer saw it. The monsoon flight to Mumbai was bumpy, and Justice Ahmadi muffled to me, "Watch my wife," he said. "She will start praying soon." Soon thereafter, I saw Mrs. Ahmadi pull out a copy of the Quran as she started reading it for protection for her and everyone else on the flight. He knew her truly well. Justice Ahmadi had a sense of humor without being trenchant. The noted astrologer, Bejan Daruwala, was a college friend. When he asked young Ahmadi whether he could read his horoscope, he replied, "How much will you pay me if I allowed you to read it?" Justice Ahmadi is survived by his children, Mr. Huzaifa Ahmadi, a distinguished senior advocate at our bar, and Ms. Tasneem Ahmadi, a leading lawyer at the Supreme Court. His daughter-in-law, Insia Ahmadi, and his beloved grandchildren, Insia, Adnan, and Ali Asgar. In an article in the Indian Express on 11 March 2023, his granddaughter, Insia Vanvati, writes that Justice Ahmadi always took out time for his family, whether it was to play a game of table tennis after the 9 p.m. news or to engage in deep and meaningful conversations about life and law. His family and confidants had the unique pleasure of observing Justice Ahmadi and learning the essential lessons of integrity, conviction, and courage under fire while maintaining dignity. Insia Vanvati captures the great loss that the legal community and the entire country feels on the passing of Justice Ahmadi. She writes, and I quote, "Although he no longer walks amongst us, and the world feels like a light has gone out without him, his legacy and memory live on forever in the hearts of all those who had the privilege of knowing him. We extend our deepest condolences to his family, friends, and colleagues. When our parents are no longer with us, fond memories and their values provide sustenance to our lives. We pray to the Almighty to give strength to the members of his family and to bear the loss, as well as to have the wisdom to pursue his values. May we find the strength and courage to carry Justice Ahmadi's legacy forward." Honorable the Chief Justice of India, Honorable Judges of the Supreme Court, Solicitor General of India, the Additional Solicitor General, President and Office Bearers of the Supreme Court Bar Association, President and Office Bearers of the Supreme Court Advocates and Record Association, esteemed members of the Justice Ahmadi family, members of the bar, ladies and gentlemen. We have gathered here today to pay tribute to the extraordinary life and legacy of Chief Justice A.M. Ahmadi, the 26th Chief Justice of India. When we gather to remember the life and times of great contributors to administration of justice, we are engulfed by a sublime environment. All minds become keen to gather the enriching memories about the life and contributions of such persona. I understand that these sublime feelings with themselves are a great persuasion to collectively stand by the noble values and goals passionately pursued by such contributors. Chief Justice Ahmadi, it can be well stated that he dedicated the entire life in the path of administration of justice in its manifold sense. By his extensive contributions in the field of law and justice, spread over several engagements and dimensions of such pursuits, the riches that have been added to the field of justice are immeasurable. With his passing away on March 2023, we mourn the loss of a great legal luminary. Destiny assigned various duties to be discharged by him, transitioning from a lawyer to serving as a civil and session judge, holding the position of a law secretary for the state of Gujarat, and in due course getting elevated as a judge at the Gujarat High Court. The sum of all the above contributions marked him as a definite candidate to becoming a judge of the Honorable Court. His contribution to the development of criminal jurisprudence are noteworthy, particularly Keshav Mahendra was MP on the intent part under Section 340 of the Indian Penal Code in the context of the Bhopal gas leak tragedy. Sanjay Dutt was a state on the indefeasible right of the accused to be released on bail within the tight scope of the scheme of Tada. Amir Shad Khan was a Himingalyana, emphasizing the dual obligation of a detaining authority. Niranjana Singh was Jitendra Bhimraj on the strict construction of terms of imprisonment under Tada. These judgments and some other important dimensions of criminal law and procedure, laced with keen insights, continue to shape the law. In the Philippine encounter deaths matter triggered by the writ petition filed by Mr. R. Suri, advocate, Chief Justice Ahmadi stood firmly in endorsement of the intervention by the court. Justice Ahmadi also found that it is the duty of the court to keep at bay attempts to stall such proceedings, which happened in the writ petition filed by an inspector of police claiming to act in a representative capacity on behalf of the UP police force. The opinion of the court is an example of the balance between the credibility and impartiality of an investigation without casting any reflection on the police force. The court engaged in a noteworthy analysis of Article 142 of the Constitution after referring to the Delhi Judicial Service Association case and the Union Carbide Corporation case. This analysis is a further reflection the Honorable Judge's keen perception of the unique feature of Article 142 of the Constitution, elevating its importance, consistent with the necessary restraint that will go into the invocation of Article 142 of the Constitution. Two thoughtful opinions penned by Judge Ahmadi deserve acknowledgement. The observation made in RKJ in the Union of India has set in motion over a period of time the importance of looking at sound tribunalization with due importance to the independence of the judiciary. The principle of suspension of a conviction of a sentence in the context of avoidance of disqualification laid down in Ram Narang versus Namesh Narang pertaining to a director of a company anxious to avoid disqualification has now become part of the law of suspension of conviction, which is inroads into election law. If one has to quickly scan the length and range of fields of law visited by judgments such as Ahmadi, we can see that it extends and the importance of the right to know about the affairs of the government formulated in Dinesh Trivedi's case, the importance of the right to exhibit a broadcast in Doordarshan, a work critical of the governmental functions, as proponent in LIC versus Madhubai Shah, the question as to whether a person who is not elected as a member of either house of parliament can be sworn into the Prime Minister, touching upon the interpretation of Article 75, among other provisions of the Constitution, answered in a fine balance of logic, relevance, and representative democracy, rendered in SP versus H.T. Devegowda, a few indelible dimensions of jurisprudence. Judge Ahmadi's dissenting view in NDMC versus State of Punjab, where he voiced a strong opinion against the court lapsing into dealing with issues not directly raised in the proceeding, is a caution forever to be kept in mind. The narration will be incomplete if we don't advert to the milestone laid by the court in the TN session case, which has added strength and substance to the election law of the country, as also the judgment in NHRC with the state of Arunachal Pradesh, with an unqualified emphasis on the life and liberty right under Article 21 of the Constitution. How can one close one's attention to three other seminal constitutional contributions rendered in Bommai, Indira Sani, and L. Chandra Kumar? No part of the important chapters of a constitutional adjudication remain uninfluenced by this opinion. In one sense, S.R. Bommai and Ismail Faruqi stand together in the staunch advancement of secularism. The post-retirement life of Chief Justice Ahmadi bears testimony to his compassion and commitment to several human causes as well as social interests. He passionately engaged himself in the activities of the Bhopal Memorial Hospital Trust on his appointment as chairman. Records show that Justice Ahmadi played a significant role in the establishment of the Bhopal Memorial Hospital and Research Center. It is said the service rendered by him is visible in the commendable quality of medical treatment made available to the gas victims, and the hospital remains even today as an important center of medical care. It's just a matter of course that he received several international recognition. His work in the amelioration of human rights violation in East Timor is exemplary. Justice Ahmadi's contribution to the cause of legal education and laying emphasis on the importance of clinical legal education and attainment of equipment, coupled with ethics, continue to inform the Bar Council of India in its ongoing engagement in the cause of legal education. The recommendation made by the committee headed by Justice Ahmadi towards the important amendment to the Protection of Human Rights Act 1993 in strengthening the NHRC with least governmental intervention is yet another illustration of the balancing of principles in conflict. His pioneering work as executive chairman of the Committee for Implementing Legal Aid Schemes opened up new avenues. I was fortunate to receive an autographed copy of his book, Flow of Thought, at the time of his launch. At a personal level, Chief Justice Ahmadi will be forever remembered by me as the Chief Justice who was instrumental in my designation as senior advocate. In addition to having been chairman of several advisory boards and Gujarat State Pay Commission, a member of the Ravi and of the Water Dispute Tribunal, Justice Ahmadi served as the distinguished chancellor of Aligarh Muslim University for more than one term. Ahmadi's legacy is not only defined by the remarkable judgment, but also by his dedication to nurturing young talent. In conclusion, let us remember that A. Ahmadi is a beacon of justice, a champion of equality, and a tireless advocate for the rights of all. His legacy will continue to guide us as we strive to build a more just and inclusive society.
Only over the 3 entries in List 2, over which NCTD does not have legislative competence. F. The executive power of NCTD with respect to entries in List 2 and List 3 shall be subject to the executive power expressly conferred upon the Union by the Constitution or by
D. The phrase insofar as any such matter is applicable to Union territories in Article 239 AA3 cannot be read to further exclude the legislative power of NCTD over entries in the state list or concurrent list over and above those subjects which have been expressly excluded. H. With reference to the phrase subject to the provisions of this Constitution in Article 239 AA3, the legislative power of NCTD is to be guided and not just limited by the broader principles and provisions of the Constitution. And I, NCTD, has legislative and executive power over services, that is entry 41 of list 2 of the 7th schedule, because 1. The definition of state under section 358 of the General Clauses Act 1897 applies to the term state in part 14 of the Constitution. Thus, part 14 is applicable to Union territories. And 2. The exercise of rulemaking power under the proviso to Article 309 does not oust the legislative power of the appropriate authority to make laws over entry 41 of the state list. We have answered the issue referred to this Constitution bench by the order dated 6 May 2022. The registry shall place the papers of this appeal before the regular bench for disposal after obtaining the directions of the Chief Justice on the administrative side.
Thank you, sir. We're immensely grateful to your Lordship.
The petitioners have urged that the order of this court dated 27 June 2022 relied on the decision in Nabam Rebia to injunct the Deputy Speaker from adjudicating the disqualification petitions. This submission cannot be accepted. Although the parties may have addressed this court on the applicability of Nabam Rebia, the order dated 27 June 2022 did not rely on Nabam Rebia to injunct the Deputy Speaker from adjudicating the disqualification petitions on the ground that a notice of intention to move a resolution for his removal had been issued. This court instead granted an extension of time to the persons against whom disqualification petitions were filed to file their written submissions in view of the principles of natural justice. Based on the submissions which have been canvassed before us, we are of the view that the decision in Nabam Rebia merits reference to a larger bench because a substantial question of law remains to be settled. The following are our prima facie reasons for reaching this conclusion. I'll not read out all the reasons for the reference to a larger bench of Nabam Rebia, save and except to note one thing. It appears that the following aspects were not considered in Nabam Rebia. 1. Whether the temporary disablement of the functions of the Speaker under the 10th schedule is prone to misuse by MLAs who anticipate that disqualification petitions will be instituted against them or by MLAs against whom disqualification petitions have already been instituted. And 2, whether a constitutional hiatus in the operation of the 10th schedule ensues because of the temporary disablement of the Speaker. To give quietus to the issue, we refer the following question and any allied issues which may arise to a larger bench: whether the issuance of a notice of intention to move a resolution for the removal of the Speaker restrains them from adjudicating disqualification petitions under the 10th schedule of the Constitution. Then we have said that pending the decision of the larger bench, as an interim measure, Adoption of the following procedure may subserve the objective of the 10th schedule, the symbols order, as well as Article 179C. It may also provide some amount of clarity and certainty. And the points which we have then made for the interim is that the investing of exclusive adjudicatory jurisdiction upon the Speaker to determine the complaints under the 10th schedule will entitle the Speaker to rule upon and decide applications questioning their jurisdiction. B. 1. The Speaker is entitled to rule on applications that require them to refrain from adjudicating proceedings under the 10th schedule on the ground of initiation of a motion for the removal under Article 179C. A Speaker can examine if the application is bona fide or intended only to evade adjudication. 2. If the Speaker believes that the motion is well-founded, they may adjourn the proceedings under the 10th schedule till their decision of their removal is concluded. On the other hand, if they believe, page 61 correction hai. If they believe that the motion is not as per the procedure contemplated under the Constitution, read with the relevant rules, they are entitled to reject the plea and proceed with the hearing. And 3, the decision of the Speaker either to adjourn the proceedings under the 10th schedule in view of the pending proceedings under Article 179C or to proceed with the hearing will be subject to judicial review. As the decision of the Speaker relates to their jurisdiction, the bar of a quae time action as contemplated in Quixote Holohan will not apply. Now, having referred the matter to a larger bench, we have given our reasons for coming to the conclusion that we are still dealing with the matter on merits because Nabam Rebia, strictly speaking, did not arise in the matter before us, but we thought Nabam, the controversy should be settled by a reference to 7 judges. So I'll now go to the what we have said on the merits of this particular case. The House of the People and the legislative assemblies of states are constituted of members directly elected by the electorate. The candidate who secures the highest number of votes is returned to the assembly. The political party which reaches the halfway mark forms government. A coalition of political parties may form the government if no single political party reaches the halfway mark. Articles 75 and 164 provide that the Council of Ministers is collectively responsible to the House of People and the Legislative Assembly of the state, respectively. The legislators who are directly elected by the people have a duty to hold the executive accountable on the floor of the House. Legislative procedures serve 2 objectives. First, they enable deliberation and discussion on the floor of the House to hold the executive accountable, and such deliberation also produces better constitutional outcomes. And second, they create a system to place a check on the exercise of power by the incumbent government. Certain procedural requirements prescribed by the Constitution safeguard constitutional values. This is reflected in Article 368, which prescribes a special majority to amend certain constitutional provisions, which, according to the members of the Constituent Assembly, hold a higher constitutional and democratic value. Certain other legislative procedures further democratic processes and accountability and prevent the concentration of power in the hands of the incumbent government. Article 212 cannot be interpreted as placing all procedural infringements beyond the pale of judicial review. Such an interpretation would completely disregard the importance of legislative processes in a constitutional democracy. Now, we have dealt with the whip as to whether the whip is really a whip appointed by the legislature party or by the political party. And we say to hold that it is the legislature party which appoints the whip would be to sever the figurative umbilical cord which connects a member of the House to the political party. It would mean that legislators can rely on the political party for the purpose of setting them up for election, that their campaign would be based on the strengths and weaknesses of the political party and its promises and policies, that they could appeal to the voters on the basis of their affiliation with the party, but that they can later disconnect themselves entirely from that very party and be able to function as a group of MLAs which no longer owes even a hint of allegiance to the political party. This is not the system of governance that is envisaged by the Constitution. In fact, the 10th schedule guards against precisely this outcome. That a whip be appointed by the political party is crucial for the sustenance of the 10th schedule. The entire structure of the 10th schedule, which is built on political parties, would crumble if this requirement is not complied with. It would render the provisions of the 10th schedule odious and have wider ramifications for the democratic fabric of this country. Thus, the courts cannot be excluded by Article 212 from inquiring into the validity of the action of the Speaker in recognizing the whip. On 25 November 2019, a meeting with the newly elected MLAs belonging to the Shiv Sena was chaired by Mr. Uddhav Thackeray in his capacity as the Shiv Sena President, Party President, Paksh Pramukh. The resolution notes that the MLAs unanimously resolved that all decisions in the meeting would be taken by Mr. Thackeray. A resolution was issued appointing Mr. Eknath Shinde as the group leader of the SSLP and Mr. Sunil Prabhu as the chief whip. On 21 June 2022, some members of the SSLP held a meeting under the chairmanship of the president of the Shiv Sena, Mr. Uddhav Thackeray. In the meeting, it was resolved to remove Mr. Shinde as the group leader of the SSLP and appoint Mr. Ajay Chaudhary. The resolution was signed by Mr. Uddhav Thackeray in his capacity as the president of the party on the official letterhead of the office of the SSLP. Then, having dealt with that, we say the Speaker was aware of the emergence of two factions in the Legislative Party on 3 July 2022 when he appointed a new whip and a new leader, because the resolution of the respondents specifically mentions that a split had occurred due to prevailing dissatisfaction in some MLAs of the Shiv Sena. Further, the fact that there were two resolutions appointing two different whips and two different leaders would no doubt have resulted in the Speaker inferring that there were two factions of the Shiv Sena. The Speaker, on taking cognizance of the resolution passed by the faction of the SSLP led by Mr. Shinde, did not attempt to identify which of the two persons who were nominated, namely Mr. Prabhu or Mr. Gogaole, were authorized by the political party. In a contentious situation such as this, the Speaker should have conducted an independent inquiry based on the rules and regulations of the political party to identify the whip authorized by the Shiv Sena political party. For the reasons detailed in the preceding paragraphs, the Speaker must only recognize the whip appointed by the political party. The decision of the Speaker recognizing Mr. Gogaole as the chief whip of the Shiv Sena is illegal because the recognition was based on the resolution of a faction of the Shiv Sena legislature party without undertaking an exercise to determine if it was the decision of the political party. Harmonizing the 10th schedule with paragraph 15 of the symbols order. This court cannot accept the solution proposed by the petitioners and lay down a constitutional sequence. To hold that the Election Commission of India is barred from adjudicating petitions under paragraph 15 of the symbols order until the final adjudication of the disqualification petitions under the 10th schedule would be in effect to indefinitely stay the proceedings before the Election Commission of India. This is because an order of the Speaker attains finality only after all avenues for appeal have been exhausted or are barred by the passage of time. The time that it would take for an order of the Speaker to attain finality is uncertain. The Election Commission of India is a constitutionally entrenched institution which is entrusted with the function of superintendence of and control over the electoral process. The ECI, which is a constitutional authority, cannot be prevented from performing its constitutional duties for an indefinite period of time. Proceedings before one constitutional authority cannot be halted in anticipation of the decision of another constitutional authority. In arriving at this decision, it is not necessary for the ECI to rely on the test of majority in the legislature alone. In cases such as the present one, it would be futile to assess which group enjoys a majority in the legislature. Rather, the Election Commission of India must look to other tests in order to reach a conclusion under paragraph 15 of the symbols order. The other tests may include an evaluation of the majority in the organizational wings of the political party, an analysis of the provisions of the party constitution, or any other appropriate test. Then we deal with the judgment in Sadiq Ali's case, and having dealt with the judgment, we say the disqualification proceedings before the Speaker cannot be stayed in anticipation of the decision of the ECI. In cases where a petition under paragraph 15 of the Symbols Order is filed after the alleged commission of prohibitory conduct, the decision of the ECI cannot be relied upon by the Speaker for adjudicating disqualification proceedings. If the disqualification petitions are adjudicated based on the decision of the ECI in such cases, the decision of the ECI would have a retrospective effect. This would be contrary to law. The question before this court is, what is the impact of the deletion of paragraph 3 of the 10th schedule? This question has arisen in the context of both the factions of the Shiv Sena claiming to be the real Shiv Sena. In effect, this points to the existence of a split within the SSLP. However, no faction or group can argue that they constitute the original political party as a defense against disqualification on the ground of defection. The inevitable consequence of the deletion of paragraph 3 of the 10th schedule is that the defense of a split is no longer available to members who face disqualification proceedings. In cases where a split has occurred in a political party or in a legislative party, members of neither faction may validly raise the defense that they are the political party in the event that each faction files petitions for the disqualification of members of the other faction. The defense sought to be availed of must be found within the 10th schedule as it currently stands. The deletion of paragraph 3 impacts the proceedings under paragraph 2(1)(b) as well. When there are two whips appointed by two or more factions of the political party, the Speaker, as held in the preceding section of the judgment, decides which of the two whips represents the political party. Thus, the adjudication of the Speaker on whether a member must be disqualified under paragraph 2(1)(b) would also depend on the decision of the Speaker recognizing one of the two or more whips. We accordingly answer the question referred to us as noted in paragraph 32F of the judgment. To avert a no confidence motion, the incumbent government may not advise the governor to convene a session of the assembly, and the Speaker may adjourn the sitting of the House to prevent voting for granting leave to move a motion of no confidence. If the Speaker and the government attempt to circumvent a no confidence motion, the governor would be justified in exercising the power under Article 174 without the aid and advice of the Council of Ministers. Now we have dealt with the role of the governor in the present case. The petitioners have urged that the governor was not justified in reaching the conclusion that he did on the basis of the resolution dated 21 June 2022 because 1. The 34 MLAs belonging to the Shiv Sena did not express their intention to exit the Mahavikas Aghadi government, and 2. The MLAs who signed the resolution constituted a faction of the SSLP. Although the resolution dated 21 June 2022 specifies that some MLAs of the SSLP were dissatisfied with the functioning of the MVA government, it does not record their intention to withdraw support from the government. Among the 34 MLAs who signed the resolution dated 28 June 2022, a few were also ministers in the government. On the basis of this resolution, the governor concluded that the majority of the Shiv Sena MLAs have given a clear indication that they intend to exit from the Mahavikas Aghadi government. The assembly was not in session when Mr. Fadnavis and 7 independent MLAs wrote to the governor. However, there was no attempt made by the members of the opposition parties to issue a notice for a no confidence motion against the incumbent government. The governor had no objective material on the basis of which he could doubt the confidence of the incumbent government. The resolution on which the governor relied did not contain any indication that the MLAs wished to exit from the MVA government. The communication expressing discontent on the part of some MLAs is not sufficient for the governor to call for a floor test. The governor ought to apply his mind to the communication or any other material before him to assess whether the government seemed to have lost the confidence of the House. We use the term opinion to mean satisfaction based on objective criteria as to whether he possessed relevant material and not to mean the subjective satisfaction of the governor. Once a government is democratically elected in accordance with law, there's a presumption that it enjoys the confidence of the House, there must exist some objective material to dislodge this presumption. The MLAs did not express their desire to withdraw support from the MVA government in the resolution dated 21 June 2022. Even if it is assumed that the MLAs implied that they intended to exit from the government, they only constituted a faction of the SSLP and were at most indicating their dissatisfaction with the course of action adopted by their political party. The political imbroglio in Maharashtra arose as a result of party differences within the Shiv Sena. However, the floor test cannot be used as a medium to resolve internal party disputes or intra-party disputes. Dissent and disagreement within a political party must be resolved in accordance with the remedies prescribed under the party constitution or through any other methods that the party choose to opt for. There is a marked difference between a party not supporting a government and individuals within a party expressing their discontent with the party leadership and functioning. The governor is the titular head of the state government. It's a constitutional functionary who derives his authority from the constitution. This being the case, the governor must be cognizant of the constitutional bounds of the power vested in him. He cannot exercise a power that is not conferred on him by the constitution or a law made under it. Neither the constitution nor the laws enacted by parliament provide for a mechanism by which disputes amongst members of a political party, particularly, can be settled. They certainly do not empower the governor to enter the political arena and play a role, however minute, either in inter-party disputes or in intra-party disputes. It follows from this that the governor cannot act upon an inference that he has drawn that a section of the Shiv Sena wished to withdraw their support to the government on the floor of the House. It is true that the letter dated 25 June 2022 sent by some MLAs of the Shiv Sena to the governor, requesting him to issue directions to the appropriate authorities for the restoration of their security, details mentions that those MLAs no longer wanted to be a part of the corrupt MVA government. However, this cannot be taken to mean that they had withdrawn their support on the floor of the House. Nothing in any of the communications relied upon by the governor indicates that the dissatisfied MLAs from the Shiv Sena intended to withdraw their support to the Chief Minister and the Council of Ministers. At the highest, the various communications expressed the fact that a faction of the MLAs disagreed with some policy decisions of the party. The course of action they wished to adopt in order to air their grievances and redress them was, at the time the floor test was directed to be conducted, uncertain. Whether they would choose to enter deliberations with their colleagues in the House or in the political party, or mobilize the cadres, or resign from the assembly in protest, or opt to merge with another party was uncertain. Therefore, the governor erred in relying upon the resolution signed by a faction of the SSLP MLAs to conclude that Mr. Thackeray had lost the support of the majority of the House. Second, the governor relied on the letter dated 25 June 2022 from 38 SSLP members, claiming that the security provided to them and to their families was illegally withdrawn. The MLAs claimed that the security was withdrawn to coerce them into continuing to support the MVA government against their free will. Therefore, they demanded the restoration of the security provided to them and to their family members. After receiving the letter, the governor issued directions to the state police to provide adequate protection to the MLAs, the members of their families, and their property. However, the lack of security to the MLAs has no bearing on the question of whether the government enjoys the confidence of the House. The appropriate response of the governor in such cases is to ensure that security that they were lawfully entitled to continues to be provided to them if it has been removed. This was an extraneous reason that was considered by the governor. The third communication that the governor relied on is the letter dated 21 June 2022 addressed by Mr. Eknath Shinde to the Deputy Speaker, stating that the appointment of Mr. Ajay Chaudhary was illegal. The governor may not inquire into or express an opinion on the validity of proceedings of the legislature. That is exclusively within the domain of the legislature itself, or in certain circumstances, discussed in the previous segment of this judgment, within the domain of courts. The discretionary power of the governor under Article 163 of the Constitution is limited to situations where a constitutional provision expressly provides it, or where the Constitution cannot be construed otherwise than to grant such discretion. Hence, the governor ought not to have relied on the letter dated 21 June 2022 In any event, the contents of the letter did not indicate anything to suggest that the then Chief Minister, Mr. Thackeray, had lost the confidence of the House. Finally, the governor relied on the letters written by Mr. Fadnavis and 7 independent MLAs, calling upon him to direct Mr. Thackeray to prove his majority on the floor of the House. First, both Mr. Fadnavis as well as the 7 MLAs could have well moved a motion of no confidence. Nothing prevented him from doing so. Second, a request by some MLAs for a direction to the Chief Minister to prove his majority does not, taken alone, amount to a relevant and germane reason to call for a floor test. There must be some objective material in addition to a mere request to call for a floor test. In the present case, the governor did not have any objective material before him to indicate that the incumbent government had lost the confidence of the House and that he should call for a floor test. And the exercise of discretion by the governor in this case was not in accordance with law. Now on relief. Relying on Bommai and Nabam Rebia, the petitioners argue that this court has the power to restore the status quo ante and rule that the government with Mr. Thackeray as its chief minister is to be reinstated. However, this argument does not account for the fact that Mr. Thackeray did not face the floor test on 30 June 2022 and submitted his resignation. This court cannot quash a resignation that has been submitted voluntarily. Had Mr. Thackeray refrained from resigning from the post of the chief minister, this court could have considered the grant of the remedy of reinstating the government headed by him. The order of this court dated 29 June 2022 held that the outcome of the trust vote to be conducted on 30 June 2022 shall be subject to the final outcome of this batch of petitions. Since the trust vote was not held, the question of it being subject to the final outcome of these petitions does not, therefore, arise. Conclusions. In view of the discussion above, the following are our conclusions. A. The correctness of the decision in Nabam Rebia is referred to a larger bench of 7 judges. B. This court cannot ordinarily adjudicate petitions for disqualification under the 10th schedule in the first instance. There are no extraordinary circumstances in the instant case that warrant the exercise of jurisdiction by this court to adjudicate the disqualification petitions. The Speaker must decide the disqualification petitions within a reasonable period. C. An MLA has the right to participate in the proceedings of the House regardless of the pendency of any petitions for their disqualification. The validity of the proceedings of the House in the interregnum is not subject to the outcome of the disqualification petitions. D. The political party and not the legislature party appoints the whip and the leader of the party in the House. Further, the direction to vote in a particular manner or to abstain from voting is issued by the political party and not the legislature party. The decision of the Speaker, as communicated by the Deputy Secretary to the Maharashtra Legislative Assembly dated 3 July 2022, is contrary to law. The Speaker shall recognize the whip and the leader who are duly authorized by the Shiv Sena political party with reference to the provisions of the party constitution after conducting an inquiry in this regard and in keeping with the principles discussed in this judgment. E. The Speaker and the Election Commission of India are empowered to concurrently adjudicate on the petitions before them under the 10th schedule and under paragraph 15 of the symbols order respectively. F. While adjudicating petitions under paragraph 15 of the symbols order, the ECI may apply a test that is best suited to the facts and circumstances of the case before it. G. The effect of the deletion of paragraph 3 of the 10th schedule is that the defense of a split is no longer available to members facing disqualification proceedings. The Speaker would prima facie determine who the political party is for the purpose of adjudicating disqualification petitions under paragraph 2(1) of the 10th schedule, where 2 or more factions claim to be that political party. H. The governor was not justified in calling upon Mr. Thackeray to prove his majority on the floor of the House because he did not have reasons based on objective material before him to reach the conclusion that Mr. Thackeray had lost the confidence of the House. However, the status quo ante cannot be restored because Mr. Thackeray did not face the floor test and tendered his resignation. And I, the governor, was therefore justified in inviting Mr. Shinde to form the government at the behest of the BJP, which was the largest political party in the House. This batch of writ petitions is disposed of in terms of the conclusions and directions recorded above.
Grateful to your lordship.
It will immediately. Without correction.
Deeply obliged.
No, no, obliged, your lord.
Deeply obliged.
Thank you for all your assistance. We have thanked the members of the bar.
No, we are really
You can never write
very
about the
patient
thoughts of
hearing.
it will come. Thank you.
Thank you.
To the extent that it relates to entries 1, 2, and 18 from the legislative competence of NCTD indicates that the governance structure envisaged in Article 239AA for NCTD was only to exclude specific entries from its legislative competence. To read the phrase insofar as such matter is applicable to the Union Territories as introducing an implied exclusion of the legislative powers of NCTD with respect to certain other entries would be contrary to the plain meaning of the provision. Article 239AA establishes the Legislative Assembly for NCTD. The seats in the Legislative Assembly are filled by a direct election from the constituencies of NCTD. The Legislative Assembly of NCTD embodies the constitutional principle of a representative democracy similar to the Legislative Assembly of the state. The members of the Legislative Assembly of the NCTD are selected by the electorate of Delhi to represent their interests. Article 239AA must be interpreted to further the principle of representative democracy, To interpret the phrase insofar as any such matter is applicable to Union territories in a restrictive manner would limit the legislative power of the elected members of the Assembly. The members of the Legislative Assembly have been chosen by the electorate to act in their stead. Thus, the legislative competence of NCTD must be interpreted to give full impetus to the will of the electorate. Then, page 53. The principles of democracy